If it pleases the court, my name is Edwards initial J, and I appear with my learned senior Dowling initial J for the defendant, the Juniper Point Eatery. Your Honour, my learned leader previously stated that a fundamental principle in the tort of negligence is the failure to meet the standard of care a reasonable person could expect in the circumstances at the time. My colleague and I do acknowledge that the defendant did owe a duty of care to the plaintiff whilst he was in the establishment, but our third submission covers how the defendant did not breach this duty. The Juniper Point Eatery did not breach its duty of care to the plaintiff as they did not fail to ensure the offender had left the premises. Mr. Perry, acting on behalf of the Juniper Point Eatery, ensured the trio Mr. Stephen Sun, Mr. Branch Connolly and Miss Katie Longmire had left the premises by watching them walk away from the Juniper Point Eatery in the direction of the motel. In relation to ensuring that Mr. Donoghue was safely escorted to his car from the Juniper Point Eatery, it is our submission that the defendant did not breach a duty of care as the defendant no longer owed a duty of care to the plaintiff. As previously mentioned by my colleague, Chief Justice Gleeson stated in the 2000 High Court judgment of Modbury Triangle Shopping Centre Proprietary Limited and Ansell that in the absence of some special relationship, the law does not impose a duty to prevent harm to another from the criminal conduct of a third party, even if the risk of such harm is foreseeable. A special relationship includes relationships between teachers and students or doctors and patients, and due to no special relationship existing between the plaintiff and defendant, there is no duty to the defendant to prevent the criminal actions of Mr. Sun. I now move on to submission 4. The Juniper Point Eatery did not breach their duty of care to Mr. Donoghue, and therefore cannot be held accountable for the plaintiff's physical and psychological injuries. My colleague mentioned before the judgment of Justice Baston of the 2007 New South Wales Court of Appeal case, Wagstaff and Haslam. From Justice Baston's judgment, there must be knowledge, either actual or constructive, of the aggressive character of a person when intoxicated, based either on known characteristics or conduct on the occasion in question. The Juniper Point Eatery did not notice any aggressive behaviour toward other patrons by Stephen's Sun on the night in question, and therefore, with regard to the before-mentioned case, the Juniper Point Eatery did not breach any duty of care to the plaintiff. To reiterate our arguments, Your Honour, there was no breach of duty by the Juniper Point Eatery during Mr. Donoghue's patronage of the establishment, and no duty of care was owed during the subsequent criminal assault. There was no breach of duty by the Juniper Point Eatery in relation to security arrangements on the night in question. There was also no breach of duty in regard to Mr. Donoghue's safety when leaving the premises of the Juniper Point Eatery. Finally, the Juniper Point Eatery did not breach their duty of care to Mr. Donoghue at all, and therefore cannot be held accountable for his physical injuries caused from the night in question. Our client did everything possible in their power in order to avoid conflict at the establishment, and this was done by taking control of the situation when they did actually in fact owe the plaintiff a duty of care. On the basis of the above submissions, counsel for the defendant respectfully requests that all claims made by the plaintiff in this matter be dismissed with costs. Thank you, Your Honour.